Hi, my name is Jatin Popat. I am a lawyer by profession and I have experience for last 30 years. I'm a founder of WillJini, which is India's first succession services company. We have been providing will and succession services to thousands of Indians and NRIs since 2014. So, today's topic we want to cover how to write a will. Will is generally called a wasiyatnama. Will is a declaration of a person about his wishes. Writing a will is not complicated. You can write it on a plain paper. So there is a myth in all the people that you have met. Please understand, Indian government has said a will can be written on plain paper. So that is a very simplifying your thoughts about will writing. It can be written by hand or by computer. It can be written in any language. So this is a very basic thing about will writing. Now, people also ask who should write a will. Now, will can be written by any persons when he has hold any single property or any property where they want to give it. There is no age bar. 18 years and above, anybody can write a will. People don't have date of expiry. So it's not that we are going to do it at 80 years or all. So it is normally people with the 35, 40 years, they start writing a will. Once they have a wealth, basic wealth, they have insurance policies, they are married, they have got kids. These are the typical crowd that we have been helping for writing a will. Now let me take the few steps one by one of a content of a will. The first thing that you want to cover is yourself. Whether you are a male, female, married, unmarried, or divorcee, or a widow, all the people who should mention about themselves, about their basic detail, about their PAN card, Aadhaar card number, just to identify. People who are NRIs can mention a passport number. So, secondly, you should cover complete detail about your family. The family includes your spouse, your sons, your daughters, their spouses, the grandchildren's, your parents. You can mention about your brothers, sisters if they are really dependent and you want to really give something to them. So it is not that whether you are giving or not giving, it is basically you are covering almost all the families. People who are divorced, they can mention about their earlier husband or wife detail. People who the spouse has been deceased, they can mention about the detail. So basically this covers the complete detail of your close family. It should not happen that some random person come in future and claim your asset because you are declaring your family yourself. So this is limited to your family, which nobody outsider can come and claim your assets. Thirdly, what we are taking here is list of the assets. Very, very important. So what we are doing today here is writing each and every of your asset so that your family, they don't have to do a treasure hunt. You are giving complete detail about your immovable property, your business, your movable asset, which include your insurance policies, your jewelry, your locker, your bank account, your demat account, and all the assets which could be your intellectual property right, your fixed assets, all the things that you are mentioning, right? So here what is happening, the more detail you give, it is good for the family that they don't have to go outside the world and trace if you are not there. Also, you can avoid writing a value of a particular account, like a bank account has so much of balance. You can avoid writing a value for a flat or anything. Just give a basic detail that I have a bank account, which is which bank and what is the number. I have demat account, which demat company or your depository you are holding and what is the number. So this is a basic detail you are giving. So it helps family, right? And everybody knows that values is dynamic. It gets changed, which will be a guide for your family about each and every of your asset. The people are also writing about their artifacts, about their pets, and so many things they mention, whatever they hold, right? So anything what you have in a single name or a joint name, please mention. If you are a joint holder, then your portion is only to the extent of your share in the joint, whether it's a flat, whether it's a business, whether it's any bank account. So if you are, say for example, you have a bank account with the two names. So technically, half of the portion is your spouse, half of the portion is yours. Even though your spouse has not invested or put the money into bank account, or say example in a flat, you normally in India we have a system no making all the asset in a joint name with the spouse. It's a tradition and practice in India more, and hence whenever you add your spouse name for or your children name as a joint owner, so they are not actually invested, but you have indirectly given a gift for that portion. So they equally are owning the asset. So you have to write about your part, they will write about their part of that ownership of a particular asset. So no, this is a very clear that please mention all your asset, whether it's a single name or joint name. You can mention in the will that this particular flat I am owning 50%, this particular bank account I am 100%. You can mention that way. So this way you are guiding your family, your holdings, right? You can add also one point about nominations. If you have in past done any nomination in that particular thing, you can add. That's going to be a guiding point for you and them. However, later on, you please change the nominations as per the will request. So this is a complete instruction or a detail that you are giving to your family about each and every asset. Now the next thing that you can add is distribution of the wealth. Now you have been earned this wealth for many years, and now you want to decide what will be given to whom when you are not there. Please understand, this will you can write any number of times, and it will be used only after the death of a person who is writing. So there is no relevance of a paper when you during your lifetime. Nobody can use it. Okay. So this is very basic thing. Will only is to be used after the death of a person. So no worry if you even write many wills in a life. Now distribution wishes, people also have to mention about whom they want to give a particular asset. Either they can give asset wise or they can give percentage wise. So we have been helping people in writing this will, and there are people who come with the different wishes. Sometimes they say, out of all my 100% asset, give 50% to my spouse, give 25% to my daughter, give 25% to my son. These are the way like a percentage wise. And there are people who write each asset, like a bank account, I want to give it to my son, my business will handle by my daughter, my immobile property will be taken by my wife. So this is the way you can mention. Either you make a percentage wise or either you make a asset wise. You can do hybrid also, some percentage wise, some asset wise. So this is the distribution wishes which you can clearly mention. So don't make any ambiguity. Like, if many times people write something in the will part differently and something in differently. So no, those ambiguity, contradiction should be avoided. It should be very in a simple language that I want to give in this fashion. So please understand, don't contradict yourself in a will. So, because sometimes people say everything will go to my spouse, and then at the second stage they say my FD will go to my daughter. This is not the way. You should maintain consistency and no contradiction. Make it a simple language. So people to whom you want to give are called beneficiaries. Sometimes they may predecease you. You have mentioned your parent name or a spouse name or somebody in the family, but unfortunately they predecease you. So this is something happening. It's a life cycle. So nobody knows who is going to go first. So that is why we have to have planning. A will document can have alternate beneficiary. So you can mention if in case my spouse is not available or my mother is not available or my kid is not available because of any unfortunate incidents, then the second person will be the person who will take over that right. So it is called alternate beneficiary. So this is something also you can mention in your will, which will help you in the cases where the person is predeceased you. And you don't have to write a new will for that purpose. So any time in a life, if you don't write new will, this will cover the situation where somebody within the beneficiary is predeceased. So this is really a proper way that you should do. The next step that you want to you should take care to mention is an executor. Now the executor is what? Executor is a person who will distribute the asset to your family as per the percentage wise or asset wise, whatever you mentioned in the will. So he is a person or she is a person who is legally authorized to distribute. Now, keeping an executor is not mandatory. It is just a convenience for the family that if you are given asset to say 5-6 people within the family, everybody should not sit down and do distribution. It is good to keep somebody who can take the charge of all the asset and distribute as per the wishes of your a will, sometimes the probate is to be applied when there is a huge asset or there is a requirement of a probate, then executor can apply to the court to get a probate. Now the probate we will discuss in some other topics also. So this is something executor who is taking charge of your asset after your death, and they distribute one by one to your family. Okay. Now executor also can be your family member, it can be your spouse, it can be your son, it can be your friend, it can be your professional, anybody. There is no rule. If you rely on some person within the family, you can give them the charge of this executorship because you believe they will do it correctly, they will be not misusing any of their power, and that is something which you should know. So executor normally can be any person within the beneficiary, within your friends, within your relatives, anybody. And there are also ways you should mention about alternate executor, right? So what happens, like a beneficiary might predecease you, executor also might predecease you. So you can keep alternate executor. Say for example, a male person is writing a will and he has appointed his wife as an executor. He can also appoint son or a daughter as alternate executor. So that way you are keeping always alternate as a backup plan, so that even though if you don't write a will in your life, another will, this will cover all the legalities. The next one you should know, if you have a minor kids or a minor grandchild, and if you want to give something to them as a beneficiary, it is important that you should appoint a guardian. Guardian for the kids, if they get a wealth in the minority of their age, then possibly they need a guardian. Normally, parents are the natural guardians, which are you can mention in your will. And also you can mention alternate guardian clause. No, that is why something happens to guardian and they predecease you. So those are the alternate, always is better. The next is a few of the clauses that we mention in a will, which is really critical and important, so that your will, even if you are not changed in your life, it helps. Those clauses we normally suggest, like a residual clause or a future asset. These are the very important clauses. The next would be to sign this particular will. Before that, you need to have two witnesses. Now, in India, a will is genuinely called as a valid will or a legal will when it is signed by a person who has made a will, and two witnesses. The two witnesses should be there when will is physically signed. So two witnesses that you have to mention in your will, that these are the two people, they are going to witness with me when I sign the document. The witnesses can be anyone, but they should not be a beneficiaries or their close relative of beneficiaries. Beneficiaries could be your distant relative, neighbors, friends, colleagues, professionals, anybody. Many a time people feel that the doctor and lawyer is must. It is not. Most of the professionals, they don't become a witness because these legalities can unnecessarily call them in the court of law. Now, the witnesses should also not be worried because their role is just to witness the signature of when you are signing. They are not supposed to read the will. So this is really an important thing that you should know. And their role is just to call upon in the court of law if the will is challenged by somebody. Otherwise, there is no role of the witness as such. Only in case somebody challenges a will, then one of the witness can be called in the court of law to understand whether the will was signed in their presence. The other thing is, if people with the age of 60 and plus, possibly they should take a doctor's certificate as a mental fitness. Quite a few age-holding issues on health where there is a neuro-related medicines are going on. Some people are facing certain issues like Alzheimer, Parkinson's. So they should avoid writing a will when they are suffering from any neuro disorder or something like that. And the doctor's certificate would be necessary that the person who is signing a will has a mental capabilities or understanding about the will writing. So that doctor's certificate helps in case of any question comes in future about the medical condition of a person, and doctor's certificate can really help in defending the will as a genuine will. The next is, when you sign the will in front of witnesses, you should keep it in a very safe place, right? Once you sign the document, You can keep it in a safe place so that it can be your house, or it can be your safe deposit locker. It can be given it to your executor. People like us, like companies, we also store will as a custodian by charging annual cost and all. So this also is very important, where to keep the will, because many a time we have heard that one of the family member has got the will later on and they torn off because they got less and all. So this complication can be avoided if you keep your will at a safe place. The next is whether the will require registration or a notary. Now that is not mandatory. In India, a will is not a mandatory document for registration. So if you want to do a registration, quite a few people do, just to add government as one of the witness of a will. No? So that is something a very layman language, that government also has a copy of your will, and they have seen you when you visit the sub-registrar office near to your house. When they see you, you have come to there to deposit one of the copy. So there can be no challenge on authenticity of a will. Registration can help by adding some authenticity of a genuine will, and it's not mandatory. But however, if you want to do something, you can approach the local sub-registrar office. We as a company are doing all India. We have got quite a few will register all across all the cities, and we also help people in registration of will, which is an additional cost and time of about half an hour, but it helps you. So this is all that you should know about this will, and I hope that this video will help you to make your things very simpler in the will, and also you can avoid any mistakes on this. Thank you so much.